I think it's wrong in two senses of the word. One is if you look at the actual text of the Constitution and its original meaning, it's wrong. For instance, the main argument that the government makes is under the Commerce Clause, which gives Congress the power to regulate interstate commerce, but not having health insurance, it's not commerce and it's not interstate, and therefore it violates both of the requirements that the Constitution imposes for an exercise of power under that clause. Obviously, Supreme Court precedent has interpreted the Constitution more broadly than the text and the original meaning permit, but even that precedent doesn't go so far as to allow the federal government to impose the individual mandate. Even the Supreme Court's broadest precedents are limited to regulation of so-called activity, usually economic activity, and not having health insurance is not economic activity or indeed activity of any kind. There are many different ways to address the problem of pre-existing conditions, many of which don't require the individual mandate. One very simple one is simply to say that insurance companies are not required to cover people with pre-existing conditions unless those people, if they can afford health insurance, have previously purchased it. That would have been, at least under current precedent, a perfectly constitutional way of doing it. Another might be that people who can afford health insurance might be made ineligible for various federal benefits such as Medicare or whatnot if they did not purchase the health insurance they could afford. Furthermore, it probably would have been simply possible to leave the question of mandates to the states. Massachusetts had adopted its own individual mandate. If the individual mandate is such a great way of solving this problem, there's no reason why other state governments would not copy Massachusetts' initiative. I think the fact that they have not, even in liberal states, is some indication that actually the mandate is not a particularly good way of addressing this problem.
And basically, the arguments against the constitutionality of the so-called individual mandate, the individual responsibility provision, amount to saying that Congress does not have authority to simultaneously assure that people with pre-existing medical conditions can have access to affordable health insurance, and secondly, that Congress can do that by some way other than expanding Medicare to cover all adults or some other form of a single-payer, government-run health insurance system. What Congress has tried to do is get to universal coverage, protect people with pre-existing medical conditions, but do so within the framework of the existing mixed public and private insurance system that we have. The arguments against this position amount to the claim that the Constitution gives unelected judges the authority to impose a straitjacket on Congress such that they can only achieve those very valid and lawful objectives and socially needed objectives through one route, namely a genuine semi-government takeover. I don't think that that's what the Constitution means, and in the end, I don't believe that 5 members of the Supreme Court are going to agree with that either.
If the Supreme Court were to uphold the mandate, the practical and probably inevitable result would be that Congress would have virtually unlimited power to impose any mandates of any kind. And that, I think, is both contrary to the text and the spirit of the Constitution, and it's also a very dangerous power for Congress to have, because just as the health insurance industry was successful in lobbying for the individual mandate, even though President Obama initially opposed it, so too there are lots of other interest groups out there who would be very happy to lobby for mandates requiring people to buy their products.
Yeah, precisely because the legal theories behind these lawsuits challenging the health reform mandate are so out of kilter with existing law, they will cause an earthquake if a majority of the Supreme Court accepts them. And the tremors will be felt throughout constitutional law, and most importantly, they will be felt throughout the entire fabric of all sorts of laws and programs that Americans now take for granted. Civil rights protections will be threatened. Environmental protections will be threatened. Safety net programs could be threatened, such as Medicare, Social Security, the State Children's Health Program. All of these programs will now have to be reevaluated in terms of whether there's a constitutional basis for them or for all of their parts.